you already on that one, Mr. Carter?
Sure.
We're on the record in the matter.
I don't,
Oh, I don't think your client's here. No?
he should be on Zoom.
Let me see, I can't see him. He must not be here yet. We'll wait. Okay. Mr. Evans is representing himself.
That's why we need to go on the record, Judge,
Yeah.
to get to the bottom of that.
Okay, Ricky Evans. Okay, we're on the record in the matter, the people of the state of Michigan versus Ricky Remont Evans. Phone number is 23-00897. Appearance for the record, counsel.
Good morning, Your Honor. Kristen on behalf of the people.
And Mr. Evans is present via Zoom. You can hear us, correct, sir? Mr. Evans, can you hear me?
Yes, can you hear me?
Okay, I can hear you now. Today is the date set for a probable cause conference. This matter is currently scheduled for preliminary examination on July 7th at 10:30. I have here that you are without counsel. Did you request court-appointed counsel, sir?
Yes, I did want one. I don't know where to go.
Okay. Okay, and so he was denied?
I can't hear him. I don't know what to say.
Can you speak up because we're struggling to hear you?
I said yes. I was looking for. I didn't know where to go.
You made a request for court-appointed counsel?
Yes,
Okay, and when did you make that request?
I don't have that in the system that he did.
it was the last time I went to court. The last court date.
Did you do an intake?
I'm not sure what that means.
Ms. Donnelly, can you see if Ricky Evans did an intake? He, I believe, requested court. He did. He requested court-appointed counsel back in March, but then he retained Mr. Dillon, and then Mr. Dillon withdrew.
My understanding, Your Honor, the last time he appeared and Mr. Dillon withdrew, you directed to apply for a public defender. I don't have anything in our system that shows that he.
He likely did not complete an intake then. Okay. Mr. Evans, hang tight. We're gonna have to get you in a private meeting room with the public defender because you're gonna need to do an intake to see if you're eligible for representation by the public defender's office, okay?
All right, thank you.
No problem. Ms. Donnelly, you were here on Wimberley?
Yes, Your Honor, and Valencia.
Did Wimberley or Valencia appear?
No, Mr. Wimberly is in TRICAP. I was hoping that we have an offer. Hopefully we can, if we adjourn it to the PE that's set for next Friday.
I'm sorry?
She's in person. Valencia's downstairs.
Okay, so let this thing, you sent it to TRICAP, another matter. There is an offer on this one, you said, and you want to do what?
Just adjourn, treat the PE next Friday like the probable cause conference, and I will contact TRICAP and see if I can get him to appear, because Ms. Rolfs indicates that he might be able to TRICAP.
Okay, I'll convert PE to PCC, so no witnesses need to appear. Thank you. Okay, Valencia is downstairs, okay. Who's this in custody?
That's Mr. Polito, Your Honor. Mr. Goodrich is representing him. He's actually on the record, and Judge Warren coming here next.
Okay, sounds good. Mr. Doig is present now. Are we running on today? Mr. Doig, can you hear me?
Oh man, I gotta start my video. Oh,
Can you hear me, sir?
Yes, ma'am.
Okay. Are you able to get to a stable position so you're not walking around?
I am. Yes, ma'am. I'm sorry.
Ms. Donnelly, are you able to log on and do an intake for Mr. Evans?
I'm logging in right now.
Okay, wonderful. Thank you. I see you. Let me put you in room 1. You said PCC.
Yes.
And then we'll set a new PC after that. Okay. Thank you. Find that file
But on the tenth.
that we were looking for.
I don't know if she's gonna leave it on or she's gonna take it from your offer.
Did Lex or Spitzley appear?
They were both here.
Oh,
Yeah.
I'm gonna go pump right now. I was gonna cover Mr. Evans.
okay. Are they out there? Okay.
Do you want them, Brian?
No, we're waiting for when Mr. Goodrich comes back. They can come. Okay, Mr. Joy, can you hear me?
Yes, Your Honor.
Okay, we're on the record in the matter of the people of the state of Michigan versus Brian James Joy, file number 23-01836. Council appearances, please.
Good morning, Your Honor. Melanie Smith, Assistant Prosecuting Attorney on behalf of the people.
May it please the court, David B. Carter Jr. on behalf of Mr. Joy, who is present through the Zoom app.
Thank you. Today was the date and time set for probable cause conference. This matter is scheduled for preliminary examination next week, July 6th at 9:30 in the morning. Are we continuing to exam at that time?
I believe we are, Your Honor.
Yes, Your Honor.
Very good.
My only concern is that we have your res for that day too, but I'll be prepared. Your res? Jose, your res is a prelim on an attempted murder. I think that might be short.
Well, we do have a case with Juarez, and he has a couple.
Okay.
July 6th, yes, we do.
But
Are you thinking are you thinking time wise? Is what
Yeah.
you're saying? Oh,
I
We'll
think.
work it out.
Okay.
I'm sure we'll be here. I mean, we might skip lunch, but we'll get it
All
done.
right.
Either having breakfast. Okay, so any other issues that we need to address while we're on the record on this?
Yes, Your Honor. The people would like to ask the court to consider a bond amendment.
Okay, you can make your motion.
Thank you, Your Honor. The people have no objection to most of the terms set for bond. However, I do have a concern that there was not a no contact order placed on this file. These are assaultive charges, that being domestic violence, third offense, and child abuse in the third degree. At the time of arraignment, the only condition that was put in place was no assaultive or threatening behavior to those individuals. I have a concern that defendant would not follow those conditions, so to speak, if given the opportunity to be in the presence of these people. His history, as far as it comes to domestic violence specifically, is quite lengthy and very disturbing. He had his first domestic violence in 2004 as a juvenile, another in 2005 as a juvenile, his first adult conviction for domestic violence in 2007, another for aggravated DV in 2011, DV third in 2020, as well as an assault, GBH, or strangulation in 2020. And that's not to include the over half a dozen dismissed domestic violence charges that he's had in that same time. Your Honor, he was on probation with the 30th Circuit Court Mental Health Court program at the time these assaults were committed. It's my understanding from the APA that helps that program that he's been non-compliant in that treatment court and is on his way to being discharged from that treatment court due to his non-compliance. I'm just very concerned for the victims in this case, especially pending a preliminary examination, for their safety and for their ability to participate in this case without any interference or suggestive comments or behavior from the defendant. So I'm asking that the court impose a no contact order between the victims and the defendant at this time.
Okay, Mr. Carter.
Thank you, Your Honor. Well, Your Honor, I haven't heard anything that indicates that the magistrate abused her discretion when setting bond. I can tell you, I'll give you some backstories on this case. First of all, this appeared to happen on February 2nd, and the warrant, if this was so egregious and so important, the warrant doesn't get signed until May 16th or somewhere around there. My client voluntarily turned himself in. So the prosecutor's right when she says he was on probation. He's on probation in front of Judge Jamo and the mental health court program. This case, and I'm not here to argue the facts, is not what it appears to be, for one. And besides, my client is presumed innocent. He was violated for this conduct up in Judge Jamo's courtroom. At that point in time, we were challenging the allegations. The court set several different dates for the prosecutor to get her ducks in the row up there. Well, my client was incarcerated for quite some time. And the alleged complainant in this matter appeared at most of his court hearings. Judge Jamo finally released my client on a PR bond, knowing the circumstances of this case and knowing my client's history in the mental health court program, allowed him to return home and did not issue a no contact order. He's still on probation in that case. We have a probation violation hearing set in July in which we will be challenging these allegations. Second of all, at the hearing that the judge granted the PR bond with no conditions of no contact, knowing the allegations of this case, the Chelsea Doig appeared in court and explained to the court that CPS was involved. CPS did a safety plan for when Brian came back home to the house and didn't see a need for a no contact order. It is Ms. Doig, who is the complainant in this matter, is my client's wife. She has indicated to the court that he runs his business from the family home. That's where he runs his self-employed business in which he provides for the family, and she is unemployed. She has taken him to all his mental health appointments since February 2nd up until now. It would be a huge burden on my client's progression to get his mental health under control. And Ms. Doig indicates that she was not fearful or he has been intimidating her. I'd ask the Madam Prosecutor if she's actually talked to the victim in this matter since he was arraigned and see if there was any issues there. But I would be opposed to that, and I believe the complainant would be opposed to it.
APA Smith, did you want to respond?
I'll leave it to the court, Your Honor.
Okay, well, I think Mr. Carter asked a question about whether or not you spoke to the victim.
Yes, my office has spoke to the victim as recently as this week.
Her position on bond, the no contact,
He asked a question about her position as to no contact.
I don't ask victims' position on no contact orders. I think that as a legal professional and somebody who is representing the state, it's my duty to ensure the safety of the persons involved in these types of cases. And it's my position that a no contact order is in the best interest at this time.
Okay. And was he in fact violated in the circuit court for this same event?
That's pending, Your Honor. I believe the hearing is set in July. APA Maycomer would be handling that matter.
Okay, and what was his bond on that?
I am not aware of what his bond is on that, Your Honor. I apologize.
Okay,
I can recall it's the normal standard and conditions, but there was the judge specifically did not put a no contact order on that.
okay. I do have a concern that this was an incident that took place allegedly in February. It's almost 5 months next week. Well, no, 2 days. It'll be 5 months later. And I don't see where there's been any allegations of further abusive or threatening contact between these parties, unless I'm missing something. Was there something else going on in those last 5 months?
Absolutely not.
Why, then in my opinion, at this time, their bond was appropriately set, and I don't think there's a reason to address the no contact order the magistrate did put in place. No assaultive behavior towards Chelsea Doig and Julian Mijas. My understanding would be that was a determination made maybe after her understanding of more information than I have before me at the time of his arraignment. Let's see. And it doesn't even indicate that he's not to be in the same address with them because that's where he's living.
Yeah, that's where he's living. That's where he runs his business. That was all divulged to every court, Judge Jamo and even the magistrate.
Okay, it sounds like unless I have some information that would dispute that Ms. Doig, the alleged victim in this, is also playing a substantial part in his treatment process.
That is correct.
Okay, and then it also appears that at least at this time, there's not been any ongoing concerns as it relates to his treatment, that he's been following up with that care. And maybe that would be why we don't have any allegations of any concerns between the time that this allegedly happened and the issuance of this, which didn't get issued actually until June of this year. At this time, I'm going to deny the bond motion. Bond will continue as set. This matter will continue to preliminary examination on July 6th at 9:30 in the morning in person at the court. Do you have any questions for the court today, Mr. Doig?
I do not, Your Honor. Thank you.
Okay, so let's see. We have, you said, wait, who are we on next week? It was supposed to be one.
Oh, he said Juarez.
Juarez,
Yes.
what's our exam document?
Okay. Any additional matters for the record?
No, Your
Your
Honor.
Honor.
Thank you. You're all set.
Thank you.
Ms. Donnelly, Mr. Evans was all set.
Yes, I did. He just didn't know what his next court date was.
He's, did he log off or is he?
I asked him if he wanted to know, he could have just left the breakout.
I don't see him in the breakout room, but let me see if this is him in the waiting room.
No, I just wanted to see if he qualified first.
Yeah, it's not him. So we'll treat his next court date as a PCC.
Yeah, okay.
Oh, I actually already converted to that anyways. Yeah. Who was in the jail? Polito?
Yes, that's Mr. Goodrich.
Mr. Goodrich is not here yet,
I
though.
can find that vital right
I think it's about,
Steve?
he doesn't have anyone, yeah, the special church, so she adjourned. PE. About another. Misdemeanor, yeah, the roll, Kristen told me it was attend.
Okay.
You said Wimberley's in custody? No.
No, yeah.
It's like that.
Valencia should be
Okay, I
downstairs.
already handled that one, that's right. Valencia is in custody. Okay, Evans, we took care of. Polito, we're waiting for Goodrich. We just did Joy. Okay, let's see. We're on the record in the matter of the people of the state of Michigan versus Frank Andrew Stevens, file number 22-03370. Appearances for the record.
Morning, Judge. May it please the court. My name is Richmond Riggs, P33863. I'm an Assistant Attorney General. I appear on behalf of the people of the state of Michigan, along with my co-counsel, Ms. Lamerman, who also appears.
Thank you, Don Passenger, P39384. On behalf of Mr. Stevens, I'm battling a substantial summer cold today, so I have very little voice and it's difficult to talk, so I apologize in advance if I'm difficult to hear.
John Moodhart, Your Honor, co-counsel for defendant Stevens.
Okay, did we get everybody?
Mr. Stevens is also present, Your Honor.
Oh, okay, very good. Today was the date and time that we reset probable cause conference. The parties were still working through discovery and possible resolution at our last court date. How are we proceeding at this time?
Judge, I would request if the court would put counsel and myself and Ms. Lamerman in a breakout room. I think we need to discuss some matters before we advise the court which way we're headed.
Sounds good. Let me see if I put you in room one with.
I note that Mr. Stevens was just added, Your Honor, so if he could know we're going to a breakout room, that would be great.
Okay, do you want Mr. Stevens in the breakout room?
No, I don't believe that's necessary, just counsel, but I wanted him to know because he didn't hear the previous conversation. I think he just got added.
Okay, sounds good. Let me see, Mr. Riggs. Did I miss somebody? Mr. Okay, I think I got them all.
That was a lot.
I know. Okay, who's on the Samsung SM? Sir?
Yeah.
Sir, with the beard and the black shirt, what's your name?
David Nelson.
Yep. You have a case number?
No, I'm sorry, I do not.
Okay, which courtroom you looking for?
Simmons?
Okay, and then what are you here for, a criminal or a civil matter?
Civil matter with myself and Derek Hartwell.
Mr. Hartwell.
With a 940 summons.
Mr. Hartwell, do you have a case number? You're muted.
Yes, ma'am, we do. And David's with me. Our case number is 23-00843 GZE.
Oh, I don't know why their name is not on here, but it's the 1420 LLC.
Yeah, we requested that you set aside.
Oh, I see it. They didn't put your name on my docket for some reason. It says 1420 LLC. Okay.
Yes, ma'am.
Thank you. Let's see. Okay, well, can we have someone bring up Valencia? What are we doing now, actually?
Your Honor, you sentenced Miss Valencia to complete CATS and then she could be released to probation. And I believe she did, but we need the sentence kind of tweaked so that she can just get rid of there says there's a bed waiting for, she's on the waiting list at Glass House. So my understanding, if we can just convert it to a probation term, have her do, I would say 7 to 14 days in jail to be released to Glass House, just so she stays in there until the bed's ready.
Okay, well, can we have security bring her up, please?
Absolutely, Judge.
Oh, Mr. Polito? Yeah. Mr. Polito, you need to make some movement in there so the light comes back on. There you go. Thank you. Overrunning Karatni? No, he's a plea.
Rodney's a plea.
Armstrong.
They said that.
That's right, okay.
And the witness for Armstrong is in custody, so they should be downstairs.
I'm sorry, who's
a witness?
Oh, okay. They were read it over as well.
Yeah.
Okay, there's Mr. Goodwin.
He's
on Zoom too. Okay.
Yeah. Oh, yeah, he's right there, actually.
Your Honor, I have sentencing for Spitz is ready to go, and I could talk to Mr. Polito in a minute. You want me to do that first?
Oh, we can do the sentencing first.
Okay.
Is Spitzley here?
Yes, this is Mr. Spitz.
Okay, what about Lex?
Lex was here. I didn't see him in the hallway when I just got out of Judge Ward, so I don't know if he.
Okay, sounds
good.
I've seen him.
Maybe he has to go feed his meter or something.
Yeah.
Okay, we're on the record in the matter of the people of the state of Michigan versus Davion Spitzley, file number 23-01060. Appearance for the record.
Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Spitzley, who is standing to my right.
How are you, Mr. Spitzley? And welcome to you. Today's the date and the time that was set, or reset for sentencing. Let's see, I do have a pre-sentence report and recommendation. Did you get a copy of that?
Yes, Your Honor.
We need to make corrections, updates, or deletions.
Yes, we would like to update that he is now employed. He's doing work for Fast Temps, primarily cleaning up apartments in a temp job type of role.
Okay. Is it Fast Temps?
Yes.
Any other changes?
No, Your Honor, that is the only correction that we have.
Ready to make allocution.
Thank you, Your Honor. Your Honor, Mr. Spitzley, I think understands he made a mistake that evening, not just pulling his vehicle over with the police. It looks like he's doing has a lot of positive things going on in his life. He's planning to head to Florida in about a month to begin a college football career there. He would ask the court to be able to obviously leave the state to do that, which I believe is in the Naples area. He spoke to probation about that. He's always been easy to get a hold of. He's always shows up for court on time. I would ask the court to follow the recommendation here, place him on a term of height of probation, allow him to report over Zoom for that. I think the impulse control that they found online would be certainly something that would be helpful for him to make sure we don't have any of these incidents in the future, because if we do, I think any hopes of college football would go away if we have another this type of incident in the future. Yeah. Thank you.
Did your client want to make a statement?
Yes, Your Honor.
I just want to say I learned from my mistake. And, I'm doing everything I can to better my life and make it to football in July. And I got a job. And just trying to stay out the way and do everything I can to better my life.
What does that mean, stay out the way?
Like staying away from people and just focusing on myself and trying to get on my toes. I just turned 18 and I'm trying to think about the future and stuff. Better.
So you just turned 18?
Yeah.
What year
I
were
in November last year.
What year were you born?
2004.
Anything else you want to add? So you're going to be heading to Florida? Okay. And you're going to be playing football?
Yeah.
You excited about that?
Yeah.
What's your long-term goal?
I'm not sure what I want to do yet, but I'm pretty sure I want to do a trade. Be an owner operator.
Okay. What do you plan to study while you're in school?
I'm not sure yet.
You didn't have to declare a major yet?
No, not yet. I'm still figuring that out right now.
Okay, what's happening in the 23rd? Is it football camp?
That's when I leave for football.
Okay. So you're pretty excited about that?
Yeah.
Okay. So you understand that your decisions and how you respond in certain circumstances will affect your future, correct? Okay. And something as simple as pulling over when an officer tell you to do that or being compliant. It's something you could control. Isn't that correct? It's definitely not worth it. Even if you feel like the officers are wrong, it's the side of the road. It's not the time to prove that point. You prove it in court. You understand that? You're going down to Florida and you're a black male. You need, yes? Okay, so you need to, it's imperative that you learn from this circumstance here so that you make better decisions and you're conscious about how you carry yourself while you're down there. You're going down there to play football. You have a bright future. You're getting this opportunity because I am going to grant you HIDA status to have this non-public and put this behind you. And I don't ever want to have to see or hear about you in a negative light because of that. You understand that? I want you to be there and to thrive. And I think that because of your circumstances, you are a good candidate for a HYTA status, which means you'll have to do a term of probation. I will order you to complete 6 months of probation. You will be reporting via Zoom while on probation. You need to complete the impulse control online course, which is a Class A training center. Do you understand that? I'm going to require that you complete a 30 hours of community service as a part of your probation. You'll get 180 days to do that. However, because you're going down to Florida, it would be beneficial to you to try to prioritize getting those done sooner than later, so that you don't have to deal with that when you're down there at football camp. You understand that?
Yeah.
And if you want to know of some places or options where you can do community service, probation can provide that to you, okay? Okay, while on probation, there's a $30 per month oversight fee that you are responsible for, okay? $30, okay, service within 180 days. I am gonna grant status under HYTA. You're not to engage in any assaultive or threatening behavior while on probation, is that correct? And then you're not going to purchase or possess a firearm, ammunition, or weapons of any kind while on probation, correct? Okay. I am not going to require you to submit to random preliminary drug testing under your analysis. A, because this incident was not in any way connected to the use of alcohol, at least not as it was alleged. You're 18, so you're not supposed to be drinking anyways, correct? So. Although you're not to use, purchase, or possess alcohol, drugs, or marijuana without a valid prescription, that's still gonna be a requirement. I'm not going to require that you submit to random preliminary breath testing at this time. Do you understand that? That is subject to change if for some reason, I believe it's required that we test you during this time period. The other concern I have here is, let me grant permission for you to travel. Order for school. And you need to maintain your employment and or enrollment in school during this time, okay? Okay.
Yes, Your Honor.
Okay, do you have any questions so far?
No.
Okay, fines and costs. There's a $75 crime victim rights fee that you're responsible for, plus a $50 state minimum cost that you would also be responsible for. If you have to complete 6 months of probation at $30 per month, that is $180 in oversight fees, okay?
When is that due?
You'll make monthly payments on that, okay? And I'm gonna give you a grand total, because you'll have 125 in fines and costs, because I'm gonna waive discretionary fines and costs. That's $180 for oversight fees, it's a total of $305. You'll be required to make monthly payments on that in order to stay compliant. It's about $51 a month, okay? Okay, do you have any questions about that? There's nothing due today. There's an advice of rights as to how you could become eligible for early termination or discharge, I should say, from your probation status. You need to review that document. It tells you when you're eligible and how you can make a request if your probation officer does not make that request on their own, on your behalf. If you read that and you have any questions, I'm here to answer them for you. You have any questions about those rights? Okay. And so in your circumstance, it would be beneficial for you to get everything done as sooner than later so you can move on with your collegiate career. I need that paperwork back though, without having this looming over your head. Don't you agree?
Yes, Your
Okay. So that's the order of report. I still have your address here in the file. The address is Selfridge. Is that still accurate? Okay. And you need your probation officer in the court anytime that changes, okay? Do you have any questions at this time?
Is there anything I have to do after this?
Not until you review, you're gonna have to review this judgment or order of my sentence with probation. They'll be in contact with you, okay? But you have to review and sign it and get it back. Okay. Any additional matters for the record?
No, I guess the question just, does he need to report to the fifth floor today at all, or?
He should check in with them before he leaves. Yep.
We go to one floor to fifth floor, probation, check in with them.
You're all set, sir. Thank you.
All right, thank you.
No problem. So you're gonna log in to meet with, okay, sounds good. We're on the record in the matter of the people of the state of Michigan versus Amber Nicole Valencia, file number 22-02938. Council appearance.
Your Honor, Assistant Public Defender Sarah Donnelly on behalf of defendant Amber Valencia, who is going to be sitting right here, Amber.
How are you, Ms. Valencia?
I'm good. How are you, ma'am?
I'm well, thank you. Today was the date set for a review. Back in April, looks like I sentenced you to 365 days in the county jail, credit for 84 days. And I ordered that you be screened for CATs and substance mental health treatment, and that upon screening and recommendation, you must complete the CATs program. You said she was screened, correct, counsel?
You're right, and Ms. Valencia did appear today with the certificates of completion for 8 sessions of CATs as of June 26th of this year.
Okay.
Ms. Valencia has stated that she has, they've set up some, well, she was on, I reported that, it was my understanding she was on the waiting list for Glass House, but that was some time ago because she remained in custody. They took her off that list, but my understanding is that she has set up with MMRS for intensive outpatient programming once she is released. She also would like to be released, Your Honor, because she wants to get a job at Peckham. I believe you've been talking, they have people in the jail, so you've been meeting with them.
Yeah.
Did you do an interview or do you still have to be hired in?
I had filled out for like the hiring process. So they got my stuff.
Okay. So you're on
multiple jobs. It's like a really good, yeah, they do that program. They have like LLC and people want to do all of it. So all I have to do is 3 weeks and then I can get hired back in because I was doing sewing, but I lost it because
Your Honor, she's feeling good about where she is right now. I believe that she is appropriate now for a term of probation. And I would recommend that either she be released to probation now and so that she can get intensive outpatient programming and maintain or get a job. Or if the court still would, I think she would still be eligible for residential treatment, but she will have to be screened and wait for a placement. So again, I believe that she's been in custody since January. She completed the CAS program. It means, and I believe that she will be good to be released and put on probation at this time.
Okay, so you said there was space for her at the MMRS?
Administration recovery is outpatient services.
It's outpatient, so I was confused, where was she supposed to be? Is that what your attempts are, to go to do intensive outpatient with MMRS?
Yes, ma'am.
Okay, and so if you're released, where are you gonna reside?
2310 South Pennsylvania, that's my mom's address. She owns the house, so.
She owns the house, and she said you could live there with her?
Yes. I've been living with her. My aunt got to see my kids, so I haven't seen them. Nothing like that and stuff, so. She's been taking care of that role, like, on weekends and stuff.
And then you believe that you can become reemployed at Peckham?
Yeah, it takes 3 weeks, and now there's a better opportunity because they have Peckham Hopes or Hopes program at the jail, and I had filled out for the job application process part, so it's already filled out. And then they have LLC jobs now that they're hiring for, so it's way better than sewing. That's all I do is sew, but it's like repetition, it's over and over. I would rather do, I got training and cleaning and stuff, so LLC's having a Peckham hiring right now. I think that would keep me busy instead of just sewing.
So yeah, so we'll write down some out there.
Yes.
You look much better than the last couple times I saw you. I'm gonna say that first and foremost, okay? Face is brightening up, your eyes look good. So how do you feel?
I feel good. I mean, I'm just ready to go on the roll. I've never did 5 months in jail. I've only ever done 3 months, so. Yeah.
Intense. So you're ready to get back and being productive.
Yeah.
Now, okay?
Well, I was in a 6-year relationship, and then he was in prison, so I was the first time I've been on my own, so I just like screwed everything up a little bit, but.
Yeah, but now you get a fresh start. Okay? I'm gonna convert the balance of your sentence to a term of probation. While on probation, you are to complete intensive outpatient treatment. And you are to be employed while you're out. Provide verification of your employment to your probation officer. Do you understand that?
Yes, ma'am.
You're gonna be required to submit to random preliminary drug testing and or your analysis testing weekly. Do you understand that? If your intensive outpatient is requiring you to test, then that will offset what the court is ordering, okay? We're not gonna have you testing for 2 places at the same time, okay?
Okay. Do you know if I could just do it here until I get hired in, or because I mean I can have my mom pay for it, but my mom's kind of real tight and she keeps like how much I owe her and stuff, and I owe her a lot. She did a birthday party for me. I mean, it's cool. They don't offer it here.
No, we don't have testing here.
Not anymore. So yeah, unfortunately, yeah.
Yeah, I mean, my mom, she has money. She'll be fine. Yeah, and she's tight. She's real good. She broke down everything. She's like, this is your kid.
Okay, so I have that you'll be testing weekly. You're not to use, purchase, or possess alcohol, marijuana, or a controlled substance unless you have a valid prescription. Do you understand that?
Yes.
Not to engage in any assaultive or threatening behavior you're not to use, purchase, or possess a firearm or ammunition. You understand that?
Yes, ma'am.
Okay, do you have any questions at this time?
No, I don't.
There is a $30 per month oversight fee that you will be responsible for while out on probation, and you're also responsible for the cost of the preliminary testing, okay?
Okay,
Do you have any questions about that?
no, I don't.
Okay, you'll have to review and go over an order of probation. You're in custody at this time. We'll have somebody be in contact with you. What's the address that you're gonna be at again?
2310 South Pennsylvania.
You have a phone number.
599-517-7290.
599-72.
Say that from the beginning, 517.
599-7290. Yep.
Okay. Any additional matters for the record today, Counselor?
No, Your Honor.
Okay, good luck to you, ma'am.
Thank you, ma'am.
You're welcome. Okay, let's see. The attorneys are back on the matter for Mr. Stevens. Are we ready to proceed? Or do you need to speak to Mr. Stevens?
No, we're ready to go forward, Your Honor.
Okay, back on the record in the matter of the people of the state of Michigan versus Frank Stevens. Counsel, how would you like to proceed at this time?
And by forward, I guess I really mean sideways. We're going to be filing a motion to compel some discovery. After discussion, we've received some discovery. There's other discovery that the AG would like us to delineate carefully what we want. And so we intend to present a motion sometime in the next 30 days to the court, which would be heard. Thereafter, we would probably reset another probable cause conference and determine whether present scheduling makes sense or some additional time is required. It's a fairly extensive case with a lot of documents that go back over 6 years. And so, it's taken a bit of time to assemble. So we appreciate the court's cooperation. So our request today would simply be to adjourn for 30 days so that we could file motions, get a motion calendared with the court at a reasonable date for all parties, and then sort of take it from there, if that makes sense.
Sounds good.
To probable cause August 4th.
We'll set a next probable cause for August 4th at this time. That way we don't lose track of this case or this file pending the motion to compel that's going to be forthcoming. Once we get that, we'll set that for a hearing and then we'll reset the PCC as necessary, okay?
Very good, Judge.
Your Honor.
Any additional, thank you. 8:30. Okay. Any additional matters for the record at this time?
None, thank you. Just obviously, we continue all other things we were doing. There was a continuation of some other orders.
Correct. Bond will continue as said, and the continuation of the fingerprint order will happen until the time that he's president of the state of Michigan.
Yep, sounds good. All right.
Thank you.
Thank you.
Thank you, Judge.
Thank you. Okay, let's see. Andrew Cozy, yes. Ms. Cozy? Was it Cozy?
Your Honor.
Which matter are you here for?
Here regarding to 1420 LLC versus Derek Hartwell, case number 1-00843GZE.
You're on the record in that matter, and I do have Derek Hartwell present. Who's making all the noise? And then David Nelson is also present. Today was the date and the time that was set for a motion to set aside a default judgment due to misunderstanding of, I believe this says request. Mr. Harwell, I'm gonna be very honest, I did struggle to read your motion. If you could please read your motion to me so that I can know what you were saying.
Yes, ma'am. So, it says, I am requesting that the default be set aside due to a confusion with the lawyers. We have a trailer, and so we have lot rate, and then we have our mortgage payment. And so when we got the information about from 1421, and then we got the court date, I thought they were the same thing because they were represented by the same lawyer. But then when I realized that they were not, and once we got the lot rent thing settled, the default had already went into place with the mortgage company. So I'm asking that that be set aside because I wasn't aware that we still had to respond to that.
Okay, so you did receive notice of the lawsuit. You misunderstood or misconstrued some things. It sounds like you said something about a case before Judge Ward, but I could not read your handwriting in this. What were you indicating?
So we had to go see Judge Ward on the 9th, I believe, or right around there. And I thought it was all for one issue. Okay. But they were separate court cases. And we didn't realize it because we thought that because the same attorney was representing both parties, that it was the same issue. Okay, so that would address the good cause to set aside a default. So you also got to give me a meritorious defense. So this is a summons for value of property that they're estimating to be $78,697.76. Do you believe you have a meritorious defense to the claims made in this lawsuit? Yes, ma'am. I'm sorry. Can you just explain to me what meritorious means? Okay, you have a defense that holds a merit. That means it's a useful defense that you think. Yes, ma'am. Yes, ma'am. So we have moved out of the actual trailer and we are attempting to sell it. We only owe $54,000 on it. And the trailer is valued at 74. And so I'm assuming they're trying to make us, they're trying to put us in default without giving us a chance. I've reached out to 1421. I've asked them to allow us to make payments on it. They said no. I asked them to put the back owed amount on the back of the loan. They said no. I asked them, was there any way that we could resolve this before we go before your honor? And they said no. So I feel like they're trying to force us to go into default on this without giving us a chance to sell the trailer. Okay, and so the matter that's before Judge Ward, what is that? Is that an eviction proceeding? Yes, ma'am, that is resolved. We came up with the $3,600 to pay the past lot rent, and so we don't owe them nothing. And then there's also a buyback program that Mills Pond has that we completed an assessment back on May 29th, that it normally takes about 7 days where they'll come in and they'll evaluate the property. They have not, every time I reach out to Melissa, the property manager, and I say, hey, have you heard back from your company about buying the property back? She said that they're still waiting on an answer. Now, I know that process normally takes 7 days, so I'm not sure what's going on because I've actually did that assessment with them to buy it back. And they're still stalling, or they haven't came up with it. They haven't told us yes or no, they'll buy the property back. And I think it has something to do with this court date because I know that they're ultimately trying to take the property back, which I disagree with because I'm like, the house is worth more than what we owe. Okay, sounds good. Ms. Towsey, did you want to respond?
Yes, Your Honor. At the time, we did see that his motion that was filed, and pursuant to MCR 2.603D1. Defendant has failed to show a good cause and meritorious defense. As of today, his balance, the total balance that's currently due and owing is $8,554.10, with a total accelerated amount of $63,298.85. Additionally, the last payment that was made on the account was on June 17th, 2022, in the amount of $1,139.97. So defendant was made aware that he still had a balance that was due and owing within the loan and has failed to make any payment since June 2022. And as of this time, Your Honor, we would request that a judgment be entered and to show that this matter was, he has been given notice and allow the default request to stand, and we would be seeking a judgment on this matter.
Thank you. Mr. Hartwell, I didn't ask, did Mr. Nelson want to make any statements?
No, ma'am.
Okay, very good. Okay, well, I believe that the defendants have provided good cause, is that they had another matter pending. It was the same attorneys handling that matter, so they misconstrued the dates or misunderstood what was being resolved. Again, they're representing themselves, so some grace can be given as it relates to that. As to a meritorious defense, it sounds like they believe their defense is that the value may not be what is indicated here, or what's the value owed, I should say, the amount that they're allegedly being held responsible for in this judgment is not what they believe to be accurate. And then also, they seem to believe that they have a pending buyback application to which they believe is being stalled, maybe because of this court date, maybe not. With that being stated, I'm going to find that they have presented a meritorious defense. I will set aside the default, and this matter will be set for a pre-trial.
Your Honor, if I may, sorry.
Yes, ma'am.
Your Honor, if I may, if you do feel entitled to set aside the default request as of this time, I would request that an escrow be entered for the balance that's currently due and owing to show good cause that they are not seeking to delay this matter, and request that they be put money to the escrow amount for $8,554.10 within the court.
Okay, you can file a written escrow order and I'll sign it.
Okay.
That's not a problem, and they can obviously file any motions or objections to that once that's filed. But file that with me with my court. You can send that to Judge Simmons Courtroom at lansingmi.gov. I typically review and sign those without a hearing. And then as to a next court date, a pretrial will be set by the civil clerk's office, and so that will be mailed to both Mr. Hartwell, Mr. Nelson, and then counsel for 1420 LLC. The address that we have is 7025 Copsey Corner, lot 154. Is that still accurate?
Well, yes, ma'am. We still own the property, and I do have my mail being forwarded to my new address, or I can update my new address with the court if you like.
Yes, because you are responsible to make sure we have a valid address. Otherwise, we might end up with another default.
Yes, ma'am. My new address is 8881 Northwest 33rd Street, apartment 2, in Coral Springs, Florida, 33065.
You said Coral Springs, Florida?
Yes, ma'am.
Okay, do you have any questions for the court at this time?
No, ma'am.
Okay, any additional matters for the record today, counsel?
Yes, Your Honor. In regarding to the escrow order that I do plan on submitting to the court, I would request that money be put to the escrow within the 10 days. And then if defendants default, then I would request that we be able to move forward with the default request and a default judgment.
Okay, that is noted. And once I get that order, I can sign that. Okay, ma'am?
Thank you, Your Honor.
I have a question. If I
Yes.
come up with $8,000, which is the back owed amount within the 10 days, is it necessary then that we proceed with this case? Because then the defendants will be totally paid up.
Well, I think you would have to have a discussion with their counsel about negotiating arrangement to have them dismissed, maybe a conditional dismissal or something, but that's between you all. They need to dismiss the case for you to have to do that. At this time, they're asking the court to enter their request for you to have to escrow an amount to show good faith. And so once that's filed, and you'll get a copy of that, you can obviously file your own motions or objections as it relates to that. But I am going to allow them to, they have the right to file an order or a motion for escrow order.
Okay, yes, ma'am. Now I am aware that I have the right to appeal that.
Right, and so you should be in contact with their attorney if you think that this is something that you can negotiate, okay?
Okay, yes, ma'am. And to be honest, I don't know who their attorney is. This is, to be honest with you, my first time ever seeing this woman or even hearing her voice.
Okay, this may be her first time appearing, but she's with or here on behalf of the law firm that is representing the plaintiff. Okay, so do you need their contact information, or you're just indicating that you've never particularly seen this young lady?
No, ma'am. I need their contact information. I've never spoken to them directly.
Okay. Can you provide that for him, ma'am?
Yes, Your Honor. You can give us a call at 248-593-9090.
Okay. And just ask for anyone?
You can ask for Sandra. The contact information is actually on the summons and complaint. It would have been on the notice to appear that you would have received. So you can just ask to speak to me.
Well, okay, because I don't have that information, but thank you.
You don't have a copy of your summons and complaint, sir?
No, ma'am, I do not. The only thing I have is my motion that I filed when I came down. And it doesn't, it doesn't have like who the representing attorney is. It just has like their generic information for their company.
Okay, okay. Well, you have the number and you would ask to speak to her, she said. So that should work, okay?
Yes, ma'am.
Okay, any additional matters today, counsel?
No, Your Honor, thank you.
Thank you. Anything else for you, Mr. Harwell or Mr. Nelson?
No, ma'am.
No, Judge.
Thank you. You're all set.
Thank you.
No problem. Okay, can I, Mr. Polito and share. Okay, Mr. Brunette is here, and he was here with whom? Torres. Mr. Brunette, are you and Mr. Torres all set? Because I don't see him anymore.
Yes, we are, Your Honor. I wanted to put something on the record. I fear that maybe he misunderstood me when I was saying, to hit the button so we go back to the courtroom. I don't know if you're comfortable with me putting something on the record without him here anymore.
I'm going to call the case. We're on the record in the matter of Lafque versus Raymond Torres, file number 16-0212HGC. You can put your appearance on the record.
Thank you, Your Honor. Good morning. My name is Joe Brunette. I'm filling in for Tim Smith on behalf of the plaintiff Lafque.
Today was the date that was set for a discovery hearing. And my understanding is that the party for Raymond Torres was present. I guess was placed in a private meeting with you, and then he left the virtual court proceeding. He's not in my waiting room, but there was something you wanted to put on the record at this time.
Yes, Your Honor. Mr. Torres did agree to a wage assignment. I was hoping to put it on the record so that he would agree to it on the record, but I imagine instead we could send him a copy of the wage assignment for him to sign and then present that to the court if that's acceptable.
Correct. I think at this point, that's the only way to do it. Otherwise, I'd have to, we could reset a hearing and he'll get a notice to appear for that.
Okay. I will send him a copy of the wage assignment for him to sign and then present it to you, Your Honor. I would still request that we have a follow-up hearing if that's okay, just for the fact that we requested in the subpoena that he send us certain documents and he agreed to send those to us. So I would like to request to the court a control date to make sure that we receive those.
How much time are you looking for a control date?
I told him 30 days is what I would ask the court.
Do August 8th at 2.
August 8th at 2.
Okay. And did you say, Your Honor, that the court would send out a notice for that?
Correct.
Okay, thank you.
No problem. Any additional matters today?
I believe that is all, Your Honor. I appreciate it.
Okay, thank you.
Yep, thank you.
Okay, we're on the record in the matter of the people of the state of Michigan versus Clemente Polito, file number 23-01911, council appearance.
Good morning, Your Honor. Kristen on behalf of the people.
I'm Luke Goodrich from the Public Defender's Office, here to represent Mr. Polito, who is appearing over Zoom from the jail today.
Okay, today was the date and the time that was set for probable cause conference. This matter is scheduled for preliminary examination on July 6th, 2023 at 9:30 in the morning. Are we continuing to exam?
Yes, Your Honor, we received a plea offer from the prosecutor yesterday afternoon. I discussed that with Mr. Polito. We want to just leave the matter set for now, and we will have a decision by the 6th.
Okay, well, no, we'll continue to exam at this time. Mr. Polito, we will see you in person at the court on July 6th at 9:30. Do you have any questions today?
No, ma'am.
Okay, any additional matters on this record?
Not on behalf of the people, Your Honor. Thank you.
No, Your Honor, thank you.
Thank you, you're all set.
Thank you.
Thank you, Lex.
Yes.
Okay.
Right there.
On the record in the matter of the people of the state of Michigan versus Tyrese Lamont Letts Senior, file number 23-00041, FY, council appearance.
Attorney Luke Goodrich from the Public Defender's Office, here to represent Mr. Letts at his sentencing this morning. He is standing to my right.
How are you, Mr. Letts?
Pretty good.
Today is the date set for a sentencing. I do have a pre-sentence report with the recommendations. Did you get a copy of that, Mr. Goodrich?
Yes, Your Honor, and we do not have any changes to it.
Okay, you can make your motion.
Thank you, Your Honor. Your Honor, Mr. Letts is a person who works full-time. He's been in his children's life the whole time. This incident, I think, he understands he didn't handle it properly with his son, that he needs to have better ways of dealing with conflict with his son. We would ask the court to follow the recommendations here to grant him the term of probation with 769.4A status. He's certainly willing to do some type of, a parenting class to help learn, I think, better techniques to make sure he doesn't end up in a courtroom or damage his relationship with the son. I don't think mental health counseling would be necessary, though. I saw that was recommended. He has no history of mental health issues. He does not have an extensive criminal history in any way. So we would ask the court to follow most of the recommendations, but I would ask the court to omit the one regarding mental health counseling. Thank you, Your Honor.
Does your client wish to make a statement?
Yes, he does, Your Honor. No, he's changed his mind.
Okay. Okay, I do have a pre-sentence report here with a recommendation. I also have the defendant's prior criminal history. CPS involved in this incident?
Yes, but they closed the case.
When do they close the case?
Just a couple weeks ago, I believe.
Okay, so they closed the case with no conditions?
No condition. Guess the state picked it up.
What do you mean the state picked it up?
I don't know. All I know, they said they wasn't trying to press any charges or do anything, but they was gonna close the case, but I got a court letter in the mail that said, I guess I'm getting charged with it.
That's what we're here on.
Yeah, but other than that, CPS.
So are you saying that there was a CPS case and then there's this criminal case? Is there something more than that?
No.
Okay.
All right.
Okay, the pre-sentence report and investigation indicates that you had moderate to low needs in family, IP relationships, leisure activities, and personality domains, and low needs in all other domains. I think this was a plea with requests or no objections to sentencing under 769.4A, which would require a term of probation. Probation is appropriate under the circumstances. Let's see. Well, sentence you to a term of 8 months of probation. While on probation, you have the following conditions. Grant 769.4A status. As to the contact with the minor child. Not to engage in any assaultive or threatening contact with him. Do you understand that?
Yes, ma'am.
You follow all CPS orders. As it relates to visitation rights in contact with the minor child. You're not to engage in any assaultive or threatening behavior of any kind while on probation. You're not to purchase or possess a firearm or ammunition or weapon of any kind. Do you understand that?
Yes.
And you're not to use, purchase, or possess alcohol, marijuana, or controlled substance unless you have a valid prescription. Do you understand that?
Yes.
You will be required to submit to random preliminary breath testing and or your analysis testing. You have to pay the fee for that, okay?
Yes.
You're not to be at any bars or nightclubs while on probation. Do you have any questions so far?
Why am I getting put on drugs if it's not a drug offense? I wasn't high or intoxicated at the time. I'm not getting.
Because it's a standard order under the probation status, okay? Any other questions?
So I gotta pay out of pocket?
You have to pay for your testing, correct? Is that a problem?
A little bit, because financial wise, I take care of 2 kids and car insurance, rent. So yeah, it's kind of costly, but I make it work.
There's a cost that must be bared when you commit these kinds of actions. The other option is you could just do jail time and then you won't get the 769.4A.
I understand.
Okay. I'm gonna order that you complete parenting classes. Learn better ways to cope with how to discipline child, if this is even to be considered discipline, because it sounds like this was an incident that occurred to something outside of the child's control. Nonetheless, you need to maintain your employment and provide evidence of that to probation while on probation. I don't see where there was any time served on this, so there won't be any credit given, but there is a sentence of 365 days, which will be suspended. 365 days in the county jail, which will be suspended upon successful completion of this term of probation. As to fines of process, a $75 crime victim rights fee that you're responsible for. There's a $50 state minimum cost that you will be responsible for. Probation at 8 months will amount to $240. I'll waive discretionary fines and costs at this time. The total fines and costs will be $365. You'll be able to make monthly payments on that. That's about $46 a month, okay?
Will I be able to just pay it in full?
You can pay it in full or you can pay it as you go, whatever works best, because I recognize you did make it inquiry about the cost of the drops. You're gonna wanna prioritize that. And if that becomes an issue, I think after 90 days, you can request to have the drops removed. I'll allow you to make that request to your probation officer and I'll review it, okay?
All right.
Mr. Goodrich, can you have him review this paperwork here? This is advice and rights as to when and how you would be eligible for early termination from this probation status. You would need to complete first 50% of the term ordered with not having any violations within the 90 days preceding that request. But it also indicates on there when you would not be eligible to make such a request. You are on probation for aggravated domestic violence, and that would make you ineligible to make an early request, okay? Do you have any questions about that, Rick? Okay, you can provide that paperwork back. Thank you. When you leave here, you should go down one floor to the fifth floor, see probation and check in with them. They will prepare a judgment order as it relates to my sentence, and you'll have to review it and sign it and get it back. But today, you're just gonna check in with them briefly, and then you'll be free to go, okay?
All right.
Any additional matters for the record, counsel?
No, Your Honor.
You're all set, sir. Good luck to you.
Thank
Thank you. Okay, did I get everybody before 10:30 already? I think I did. Okay. Karat, he's gonna be a plea. That's Austin and who you?
Well, I'm at the misdemeanor. I don't know where Jared is right now.
Okay, sounds good. And then we're running Armstrong.
Yes, ma'am.
Is Armstrong here?
Yes,
He
Your Honor.
is here, Judge.
Okay.
Yes.
look like now. It's really not strong, correct? Yeah. We're on the record in the matter of the people of the state of Michigan versus Brett Krotny. File number is 22-03378. Council appearance.
Your Honor, Dale Coltrader on behalf of the people.
And good morning, Your Honor. Jared Austin appearing on behalf of Mr. Karatny, standing present to my right.
Okay, Mr. Krotny, how are you?
Your Honor, yourself?
I'm doing well, thank you. Today was the date that was set for a pre-trial and a preliminary examination. I also have file number 23-00399. And then it looks like there's also a PA 53 violation that should have been set for today. I have a clean sheet here. It says that the people are offering for the defendant to plead guilty to added count 3 of stalking under MCL 750.4118. It's a misdemeanor with the maximum penalty 1 year and $1,000 in fines. The people, upon successful plea, will dismiss counts 1 and 2 in the felony file. That's file number 22-03378. Did you want, and there's a kilogram of no further upfront jail. Did you want to accept that offer, sir?
I did, Your Honor.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do, Your Honor.
Okay, you can put your hand down. I have an advice of rights and plea information sheet. It has today's date on it. Is that your signature?
Yes, Your Honor.
Did you read this document?
I did, ma'am.
Do you understand the rights that are listed here?
I do.
And do you have any questions about any of these rights?
No, ma'am.
So you're willing to give up each of those rights here today in order to accept the offer?
I am.
Okay. So that means you're gonna give up your right to the presumption of innocence. So you're innocent, sir, until proven guilty. You have the right to require the prosecution to prove your guilt at trial by proving each element of the charge or charges being brought against you beyond a reasonable doubt. You wish to waive those rights so far?
I do, Your Honor.
You have the right to a jury trial. At the time of trial, you have the right to see, hear, or question any other witnesses the prosecution intends to call. You understand that?
Yes, ma'am.
You have the right to call your own witnesses to trial or present evidence at trial that you believe further defense to the charges being brought against you. You understand that?
Yes, Your Honor.
You have the right to remain silent at trial and not have silence be used against you. You understand that?
Yes, Your Honor.
You want to waive all of those rights today?
I do.
Okay, are you currently on probation, parole, or out on bond on any other matters other than these two?
I'm on parole.
Okay. You understand that a guilty plea could have an impact on your parole status?
Yes, ma'am.
Okay. You understand that a guilty plea could also result in a conviction that you may need to report to your current employer, future employer, or need to put a conviction on a job application?
Yes, I do.
Okay, and also a conviction can result in impact on any travel or immigration status that you may be seeking. You understand that?
Yes, ma'am.
Okay. Anybody threatening you to get you to waive your rights and plead guilty today?
No, ma'am.
Has there been any promises not stated here on the record in exchange for your guilty plea today?
No, ma'am.
Okay. As to the added count 3 of stalking, how do you plead, sir?
Guilty, Your Honor.
And are you pleading guilty because you believe you're guilty? Have a factual basis, counsel.
Yes, Your Honor, thank you. And before I begin, Your Honor, I think, excuse me, going to be an agreed upon amendment to the date range of the complaint.
Okay.
Because currently there's only one date listed, but I think we need a series of dates to justify the continual context over the course of time.
Okay, sounds good.
That's correct, Your Honor.
Thank you.
And that would be, Your Honor, of December the 19th of 22 up to February the 3rd of this year.
Okay.
And so, Mr. Karatny, that date range that I just listed, December 19th of last year, 22, up till the time period of February 3rd of this year of 23, did you have contact with an Alicia Hart?
I did.
And that was you reaching out to her over phone, is that correct?
It is.
And she did not want to have those communications with you, is that correct?
That is correct.
And that would have caused her to feel harassed, and actually did cause her to feel harassed because you were having those multiple contacts with her when she did not wish for you to, is that correct?
That is true.
And that would have occurred somewhere within Lansing, Michigan, and within Ingham County, is that correct?
It is.
Any questions from the prosecution?
No further question, Your Honor.
The court is satisfied with the factual basis. I will accept your plea. I find your plea to be made freely, voluntarily, and intelligently. This matter will be set for sentencing. Sentencing is going to be August 25th, 2023 at 8:30. Prior to sentencing, you need to meet with our probation department so they can prepare a pre-sentence report with a recommendation as to how you are to be sentenced, okay?
That's true.
There is a killer brew of no further upfront jail, but that is a agreement between you and the prosecutor. I'm not a party to that agreement. Do you understand that?
That's right.
Okay, so if at the time of sentencing, I decide that I will sentence you to further upfront jail, I'll give you an opportunity then to consider withdrawing your plea, okay?
Yes, Your Honor.
You have any questions?
No, ma'am.
Okay, counts. The counts in file number 22-3378 plus the bond violation will be dismissed. Any additional matters for the record today?
Not from the people, Your Honor.
If I may be heard on bond, Your Honor?
You may.
Yes, thank you, Your Honor. Mr. Karatny, he does have a bond that he's not been able to post in our file. He does have a hold from the MDOC because of parole. I'm just asking the court if the court would respectfully consider converting his bond, Your Honor, to personal recognizance. He's not going to go anywhere, at least not immediately, because of the MDOC hold. But at least that will be a way for them to parole, to actually see Mr. Karatny and start dealing with his parole matter. In the event that he would be released, of course, that would be up to the MDOC and parole. Mr. Karatny does have residence and certain things put into place to deal with his mental health issues and counseling upon release. But really, Your Honor, I would just ask the court to consider converting the bond to personal recognizance so that will force parole then to come see him and address the matter.
Did you want to be heard on the bond?
Yes, Your Honor. He's been in 90 days now, so I'm not opposed to that. People are not opposed. We would just ask that you keep the no contact order in place until you feel that it is appropriate to lift that.
Okay, sounds good. I think originally the bond was set at 50,000 cash surety with GPS tether and victim notification if possible, and a no contact order as to the alleged victim, Alicia Harden. Then the bond. So 50,000 personal recognizance. will continue the no contact order. Have to be within 1,500 feet of wherever Alicia Hardin lives, works, goes to school, or otherwise. You understand that?
Almost definitely.
Not to have contact directly or indirectly with her. Do you understand that?
Not a problem.
Okay. Not to engage in any assaultive or threatening behavior while you're out of custody, okay? You need to-
No, that's not a problem.
you need to report to all of your future court dates,
100%.
including your meeting with probation, so they can provide us with a report, including your sentencing, okay?
Yes, Your Honor.
Sentencing can proceed via Zoom if you have appropriate capabilities to do that, okay?
Yes, ma'am.
Do you have any questions about your bond?
No, ma'am.
Any additional matters for the record?
I have nothing additional, Your Honor. Thank you. Not from the people.
Thank you, you're all set.
Thank you, Your Honor.
Hello, Kathy. Thank you, have a good one. And happy 4th of July.
I'm sorry.
On the record, in the matter of the people of the state of Michigan versus Keto Armstrong, file number 23-01002 FY, appearances for the record.
Good morning, Your Honor. Kristen Ralph on behalf of the people.
Good morning, Your Honor. Joseph Yang on behalf of Mr. Keto Armstrong, who is present and to my right.
Good morning, Your Honor.
Good morning. Okay, today was the date and the time that was set for preliminary examination. We're ready to proceed.
We are, Your Honor.
Any preliminary matters?
I would just ask for a mutual order of sequestration.
Okay, do we have other witnesses in the courtroom?
Not to my knowledge, Your Honor, I believe Ms. Armstrong's mother is in the courtroom. I don't believe she's a party to this incident.
Okay, sounds good. Order of sequestration is granted. You can call your first witness.
Thank you, Your Honor. This one people would call Officer Pellegrino.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, ma'am.
If you can have a seat, officer. And can you state your first and last name and spell both of them?
Armando Pellegrino, ARMANDO, Pellegrino, PELLEGRINO.
Okay, you can proceed, counsel.
Thank you, Your Honor. And what is your occupation?
Police officer for the city of Lansing,
How long have you been a police officer for the city of Lansing?
approximately 4 years.
Are you assigned any special assignments?
I am the K9 unit.
And back on March 26th of 2023, did you have any special assignments then?
I did.
The same.
Yes, K9.
And were you working in your capacity as a police officer on that date, March 26th, 2023?
Yes.
And were you working in the area of Oakland and Chestnut in the city of Lansing, county of Anne?
Yes.
And what, if anything, did you observe that day that brings you to court?
I observed I don't know the year, but a red Chevy Silverado driving west on Oakland with expired tab.
And when you observed that.
Objection, Your Honor, as to the expired tab being hearsay.
I'm sorry?
Objection as to the testimony about the expired tab.
Okay, is it being offered for the truth of the matter asserted? Is the being offered for the truth of the matter asserted? That's for counsel.
Your Honor, it is, and this, I can lay more of a foundation. This witness does have personal knowledge and it's not hearsay to that.
I'll let you, I'll make a ruling after you lay for the foundation.
Thank you, Your Honor. And when you noticed that Silverado, did you have a reason to look up that license plate and lien?
Yes,
And what, if anything, did that reveal?
the registration was expired.
And lien is a system, I guess, can you explain what you utilize lien for?
Sure, so I punched in the license plate number and then simultaneously runs the plate with the Secretary of State, and then it comes back on what the vehicle's registered to and then the date that the registration expires.
Thank you. Your Honor, with that foundation, I do not believe that it is hearsay.
Objections overruled. You can continue.
Thank you. And after you ran the plate in lien, found out that the plate, license plate was expired, what, if anything, did you do next?
I then submitted a traffic stop on the vehicle.
And did the vehicle stop immediately or something else?
No, it was prolonged. It was very slow stop.
And can you explain what you mean by it was very slow stop?
Sure. So there were multiple opportunities for the driver to pull over. He passed roughly 3 side streets he could have pulled onto. In my training experience with the people that prolong the time that they use contact with them, they're typically concealing illegal weapons or contraband stuff in the vehicle.
And can you tell the court what time of day was this stop?
I don't know the exact time. I'm looking at it. It's daytime.
So was it light outside?
Yes.
And when you attempted to initiate that traffic stop, did you use your emergency light?
Yes.
And did you have your emergency lights on for the entire 3 streets the defendant passed?
Yes.
Did the vehicle eventually come to a stop?
Yes, I believe it turned south on a Chestnut and it slow rolled up that block. The houses.
And were you working this day alone or with a partner?
In my patrol car, I'm alone.
When you made, did you make contact with any individuals inside of that that Silverado?
Yes.
And can you please explain that?
I made contact with the driver, Tito Armstrong. I asked him for his documents. He explained that there's no registration, or I'm sorry, the registration is expired. There's no insurance on the truck, and then I ran him through Dean and found out that his driver's license was suspended.
Did he also tell you that his driver's license was suspended? And at this time, are you the only officer on scene or are there other officers on scene?
I believe at that time there were other officers arriving on scene.
And how many occupants were inside of the vehicle when you stopped?
Including the driver, there were 3.
Can you describe for the record where they were seated inside of the vehicle?
Sure. So the driver was Tito Armstrong. The passenger, there's a folding seat in front, and then the front passenger is a male, and then directly behind that person is a female.
And you said Tito Armstrong and you nodded towards him as the driver. Do you see the person that you recognize or that you know as Tito Armstrong here in court?
Yes.
If so, can you please point to him and describe who he's wearing for the record?
The red, blue, and white shirt with basketball teams on it.
Your Honor, may the record reflect the identification of the defendant.
Any objection for identification?
Not for the purpose of the treatment, Your Honor.
Identification is noted.
Thank you, Your Honor. After you made your contact with the defendant and you learned that he did not have a valid driver's license and that the plates were expired, what, if anything, did you do next?
I then asked the passenger of the vehicle if he had a driver's license. He advised me he did. He then voluntarily gave me his license. I ran the passenger through me as well, and I found out that he had multiple felony warrants and was arrested.
And you said he was arrested on scene. Correct. Did you learn if any of the occupants that day had a valid license?
None of them at the time, no.
And then what, if anything, did you do next?
Then I asked the driver Tito to step out of the vehicle. And I detained him in handcuffs, patted him down for weapons. And then I requested a tow truck to the vehicle since there's no valid driver's license. And there was a valid driver's license, so there's no insurance.
And so at that point, were you going to impound the vehicle?
Correct.
And then after you secured the defendant in handcuffs, what, if anything, did you do next?
I then began to fill out a citation for driving while license suspended.
And at this point, are there other officers on scene?
Yes.
Did you conduct an inventory search on the vehicle?
I personally did not.
Do you know who did? And who was that?
I believe it was Officer Rotuno, Officer Molly Brooks, and I'm not sure if Sergeant Lance Slater helped with that.
Objection, Your Honor. Lack of foundation. Did he actually observe? Is this something that he was told? Who actually did the inventory search?
Can you clarify?
Sure, Your Honor. Did you observe the officers that conducted the inventory search?
Yeah, they conducted it in front of my patrol vehicle.
Objections on move.
Thank you, Your Honor. And what, if anything, did you do next after the inventory search was conducted?
While I was filling out the citation for the driving license suspended, Officer Rotuno approached me with a small baggie containing crystal-like substance that I believe is meth. Investigation for possession of that.
Do you know if the female was arrested on scene?
She was not.
You said she was not?
She was not, no.
And did you true narc or test the substance in any way?
I did not.
Thank you. Nothing further.
Cross examine.
Thank you, Your Honor. Good morning, officer. My name is Joseph. I represent Mr. Armstrong. If you need me to rephrase or slow down, just please let me know. In the area that you pulled Mr. Armstrong over, were there a lot of one-ways in that area?
There are a few, yeah.
Okay, so you said you took about 3 streets to stop, so that's about 3 blocks, or is it like a quarter mile, or can you kind of give us a gauge of that for me?
It's a standard city
6
block,
blocks,
yeah.
so about 3 blocks before he stopped.
I would say before he completely stopped, because he also turned onto Chestnut and continued down that road as well.
Okay, but once he stopped, he was compliant with all of your commands and everything, correct? And so earlier you stated that once you found out he didn't have a valid license, you decided to impound the vehicle, is that correct?
After I found out that there was not a valid driver's license on scene to drive the vehicle, I guess.
Okay, and you made that decision, or did somebody else make that decision?
I believe it was a conjunction of all of us on scene.
Okay. And once that decision is made, who makes a decision to do an inventory search?
It's the department policy that we search the vehicle before that's towed.
Okay, so is it whoever's on scene does an inventory search, or does somebody, a specific officer, makes the decision, we're gonna do an inventory search? I guess I'm just,
sure what you're asking.
Is there a distinction between if you're on scene and the vehicle is being towed, you just search, or does somebody have to say, okay, now we're gonna search the vehicle? Authorizing the search of the vehicle.
I'm not understanding what you're asking.
Okay, does a commanding officer or somebody in charge of the first on contact have to say, now we're searching the vehicle, or do the other officers just start searching once that decision is made to tow?
Once the decision is made to tow, it's like I said, it's our policy that we search the vehicle.
Okay, so in the inventory search, do you actually take an inventory, like a written inventory?
Yes.
You do? Okay, do you know if one was submitted in this instance?
I'm not sure. Like I said, I didn't conduct it for search myself, so I did not document it properly.
So in your training experience, what kind of things are typically documented? Are like cell phones documented?
Like high value property, the police department doesn't want to be liable for it.
Okay, so something that's cell phones or power tools?
It's just whatever that officer feels comfortable documenting. Like
Okay.
I personally did.
Okay, so I'm just for policy, for your training experience
Sure,
for that policy. So it's at officer's discretion to document or not, is what you're saying? Okay, so, but there is an inventory, I guess, form that should be filled out if something of value is found.
Yeah, it's called a tow file. So when the police department tows a vehicle, we put in like the owner of the vehicle, the plate, the day it was towed, and then on the bottom is a blank little paragraph you can type in the property that was located. So,
okay. Are there, in your inventory search policy, are there specific items that need to be inventoried? Or is it just at officer discretion?
I don't believe there's like cookie cutter, like you must document computers, this, that. I think it's just, the verbiage in the policy, as far as I'm concerned, just valuable properties and stuff.
Okay.
You had stated earlier that when you stopped the vehicle, there were 3 occupants, correct?
Yes.
All right, and so Mr. Armstrong, you said was the front driver. There was another gentleman in the front passenger, and there was a female.
Yes.
Yes. And then there was a female in the back seat, correct?
Correct, sitting directly behind the passenger.
All right. Did you? And then later you said that another officer had brought you something that looked like a crystal-like substance, correct?
Correct.
Did you personally witness where those were located, where that was located or found?
No, like I said, I wasn't up there doing the inventory search. That property was brought to me at my patrol car.
All right. Further questions, Your Honor? Thank you.
Hey, you direct?
None, Your Honor.
Thank you, Officer Pellegrino. There is a sequestration order, so you cannot discuss any portions of your testimony with any other witnesses, okay? You have another witness?
Yes, Your Honor. At this time, the people would call Officer Sean Rotuno.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes.
Thank you, officer. You can have a seat. Can you please state your first and last name, then spell both of them.
Sean Rotuno, SeanRotuno.
Thank you. Please proceed, counsel.
Thank you, Your Honor. And what is your occupation?
Police officer with the city of Lansing.
Do you have any special assignments?
I am a road patrol officer at this time.
How long have you been employed as a police officer for the city of Lansing?
2.5 years.
Were you working in your capacity as a police officer back on March 26th of 2022?
Yes.
And were you working in the area of Oakland and Chestnut in the city of Lansing and County?
Yes.
And what brought you to that area that day?
Officer Pellegrino conducted a traffic stop and I assisted.
So were you a backup officer?
Yes.
And when you arrived on scene, who was present?
There were multiple other officers, obviously Officer Pellegrino, and he had a red truck stop that had 3 occupants in it.
And can you describe the occupants and where they were seated?
So there was a larger male driving, there was a smaller black male in the passenger seat, and there was a female in the back seat, I believe sitting behind the passenger.
And when you arrived on scene, were all of the occupants still inside of the vehicle, or had they been asked out?
No, they were still all inside the vehicle.
Did you observe the occupants being asked or stepping out of the vehicle?
Yes.
Do you recall what occupant was asked out of the vehicle first?
If I remember correctly, I believe it was the passenger.
Front seat or?
Oh, yes.
And so after the passenger being the first one out of the vehicle, do you recall if anyone else ended up getting out of the vehicle?
And eventually everyone was asked out of the vehicle.
And do you recall the order after the passenger was stepped out? Was the driver the next one to be asked to step out?
I believe so.
And during the traffic stop, at some point is a decision made to impound the vehicle?
Yes.
And do you know why?
It was, if I remember correctly, it was we didn't have a valid driver. From my remembrance, I believe the driver did not have a valid driver's license. The female in the back did not have a valid driver's license, and the passenger was taken to jail for outstanding warrants.
And so after the decision was made to impound the vehicle, was an inventory search conducted?
Yes,
And who conducted the inventory search?
I did.
And can you please describe for the court how you conducted your inventory search?
Yes, so I started on the passenger front side of the vehicle. Did not locate anything, any noteworthy items. So then I went around to the driver's side front and started searching there. I started at the floorboard and underneath the driver's seat. As I started to work my way up, still on the driver's side, I placed my hand on the driver's seat for support as I was coming up because I was working underneath the seat. At that time, I felt an object underneath my hand, which I didn't tell exactly what it was because I didn't recall seeing anything on the seat initially from the driver's side. So I lifted my hand to see what was there, and there was a small clear Ziploc bag with what appeared to be a crystallized substance inside that was located on the seat, the driver's side front seat.
And was this a small or a large baggie?
I would describe it as small.
And was this on the seat where, in the middle of the seat or around the end? Do you recall exactly where it was positioned?
So where I first located it, my hand, I would describe it as being in the middle of the seat. At the time, like I just said, that I was not certain what it was because I did not observe anything as I went to the floorboard of the driver's side first. So I did watch my body camera after to determine.
Objection, Your Honor, as to the testimony of the body cam itself. Body cam has not been entered into evidence.
Judge, he's viewing his own body cam. He's laid the foundation that he was present on scene. That's his body cam of what he did. He was present and has personal knowledge of. He certainly can testify to that.
And your objection is that the body cam hasn't been admitted into evidence?
But I believe his testimony is going to go into his observation of the body cam after the fact as to the location of where items are at, because the body cam has been admitted into evidence. My objection to hearsay, he can't testify as to that because has not been admitted as part of evidence.
It's not hearsay.
I don't believe the body cam is hearsay evidence. It's his body cam that he was wearing at the time of the incident, which would also be something he would use to prepare to come to court, such as his police reviewing of his police report. You disagree with that?
Your Honor, I guess the testimony is going to go. He's going to use the body cam as to identify where the location of the object that he found was. Is where I believe this is headed. And so because if he's going to be using the body cam as a foundation for his testimony, the body cam needs to be properly admitted so that so that it's part of the record and I can properly cross-examine it as actually part of the record. At this point, he's testifying as to a video that he observed. I understand it's his own body cam, but that's my objection.
Okay. And I would construe it the same as him reviewing his police report to refresh his recollection or to prepare himself for his testimony, which is common practice. So the objection is overruled. You can proceed.
Thank you, Your Honor. I don't recall if I had a question on the floor. Do you remember if you were going to answer, or should I?
You'd asked him, was the body, I think was the bag found in between the seat or the middle, and he was trying to recall exactly where it was located.
Thank you, Judge. And I think you testified it was in the middle, but you weren't sure where it started. Is that
Yes.
fair?
So where I located the bag on scene with my hand, it was in the middle of the driver's seat. Once I reviewed my body cam, because like I said, I hadn't seen it initially, I had felt it with my hand first. And then at that point, it was an unknown object. After reviewing my body camera, it appeared that the bag was in what I would describe as the right front corner of the driver's seat. So when I put my hand on the seat, the weight of it shifted it towards the middle based on where the camera showed that evidence was and where I physically located it.
And you testified that when you arrived on scene, the driver was still seated in the vehicle. Did you see that small baggie before the driver exited the vehicle?
No, I did not.
And for the record, do you see anyone in court that you identify as the driver that day? If so, please point to them and describe them clearly.
Yes, and it would be the Detroit Pistons red, white, and blue shirt.
Your Honor, may the record reflect identification of the defendant.
Any objection to identification?
Objection for purposes of agreement.
Identification is noted.
Thank you, Your Honor. After you located that small baggie with, I think you said, crystal-like substance, what, if anything, did you do next?
So prior to tagging it into our evidence locker, it was TrueNarc, which is essentially a test to try to determine what a possible narcotic substance could be.
Your Honor, may I approach?
You may.
I'm approaching People Proposed Exhibit 1. Can you take a look at that and describe for the record what document I handed you?
This is a result of the TrueNarc scan number 418, which says that there's a positive pass for methamphetamine.
And is that a accurate reflection of the TrueNarc that you did on this day in connection with this case?
Yes.
Your Honor, at this time, I would move for the admission of People Proposed Exhibit 1.
Any objections to People's 1?
No objection, Your Honor.
People's 1 is admitted.
Thank you, Your Honor. And when you tested this baggie for with using the TrueNarc, you said it was tested positive for methamphetamine.
Yes.
Did you also weigh the substance?
Weigh it?
Yes.
Yes.
Do you recall the weight?
I believe it was 4.5 grams.
And do you recall after you located the baggie in the driver's seat on scene, is there anything else you did in connection with this case?
I secured it. I transported the defendant to our jail. At the same time, I also, based on what I've already stated, as far as not sure where it came from because I had felt the object prior to physically seeing it, I also attempted to determine where it came from on scene using my body camera, using the computer inside my patrol vehicle.
And at the time that you located that substance, was anyone in the vehicle?
No.
Nothing further, thank you.
Prosecuting.
Thank you, Your Honor. My name is Joseph. I represent Mr. Armstrong. If you need me to rephrase or slow down, please let me know.
Yes, sir.
All right. So did you make the decision to do the inventory search or did somebody else make that decision?
So that is part of our policy. So once a vehicle is determined that it is being towed, our policy says that we are to do an inventory search on the vehicle.
Okay. And does that come with a form, a tow form or something that of any valuables that are found?
Usually there's a tow file complete, which is just an electronic form that is completed.
Okay. Do you know when was completed for this file?
I believe one was. I did not do it.
You did not do one?
Yes.
Okay. Did you, is there a part of your policy for the inventory policy? Are there certain items that have to be tagged or is it at officer discretion?
It's most just documentation.
Okay.
As far as.
So let's say you find something of value.
Mhm.
Is it at officer discretion to tag it or do you have to tag it? Is it a policy where, you know, if you feel it's over X amount of value, it needs to be in the inventory? Or is it at your discretion to decide what to put in that inventory?
I believe it's discretion to, I'm not 100% certain on that. I would have to review the policy.
Okay.
As far as the dollar amount goes.
Okay. So let's fast forward to when you go back, you go to the driver's side.
Mhm.
Okay. So you did not see it initially, is that correct?
Correct.
All right. And then you reached into the bottom floorboard to do a search. And then as you come up, it's just in your hand, correct?
Yeah, so I put my hand on the seat for support and I felt an object underneath my hand. And at that point, I still wasn't able to tell what it was till I stood up and physically looked at it.
So at what time did you realize that something was under your hand? Was it when you initially looked down, or was it when you started getting back up?
When I started getting back up.
When you started getting back up is when you found something, when you realized something was in your hand.
Yes, I used the seat for support to come back up from the bottom, I guess, floorboard area, and that's when I had felt it.
Okay. Earlier you had testified that you had taken Mr. Armstrong to lockup. Did you search him before you did that?
Yeah.
Okay. Did you find any illegal substances on his person?
No, sir.
Were there any other illegal substances or illegal items in any other parts of the vehicle that you found?
No, sir.
Earlier you testified about the true narc. Did you do that on scene or did you do that back at LPD?
Nope, that was at LPD in our property room.
Okay. Is that a true narc that you're assigned to, or is it just kind of part of?
Nope, it is one that remains in the property room that is for department use. We do not have our own personal ones.
Okay. Do you know if that is serviced, if it's a service, last time it was tested, anything of that nature?
So before we true narc an item, we do I guess you could call a scan to make sure its functionality is working properly, and it will give you a pass fail prior to scanning whatever it is you are intending to scan. And it did pass that time. As far as the service, I don't know what the schedule is or who exactly conducts that.
Did you conduct any interviews of the 3 occupants at all?
No.
No further questions, Your Honor.
Can you redirect?
None, Your Honor.
Okay, thank you. Officer, you may be excused.
Thank you.
I will advise you, though, there is a sequestration order, so you're not to discuss any portions of your testimony with any other witness.
Yes, Your Honor.
Thank you.
Your Honor, may I approach?
Yes.
May I publish with the court?
Yes, please. And you can call your next witness.
Your Honor, at this time, people have no further witnesses of arrest.
Thank you. Mr. Yang, are you calling any witnesses today?
Yes, Your Honor. It's very unusual, but I am calling a witness today, Miss Alyssa Hill. She is in custody and being brought up.
Oh, sounds good.
Hill, last name Hill, first name Alyssa.
Okay, you can be seated. Okay, this is your witness.
Yes, Your Honor.
Please step here. Please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth?
Yes.
Oh, I was waiting for you to be ready. Oh. Okay, raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
Okay, you can have a seat there. So there is a microphone that's in front of you, and behind you is my court recorder. She has to take down everything that's stated in the courtroom today, okay?
Okay.
All of your responses need to be verbal and loud and clear. You need to keep your voice up so we can hear you, because this glass might block out some of the sound, okay?
Okay.
Please state your first and last name and spell both of them.
Alyssa Hill, ALISSAHILL.
You can proceed, counsel.
Thank you, Your Honor. Ms. Hill, can I take you back to March 26th of 2023? Were you in a vehicle on that date? Do you remember?
Yes.
All right. And who was all in the vehicle with you?
Just me, Keto, and Caesar.
Okay. And did something happen to cause the vehicle to come to a stop?
Just getting pulled over.
Okay. And while you're getting pulled over, can you describe what? Let me slow down a little bit. How do you know Mr. Armstrong?
Just through my friends and stuff.
Okay. And the front passenger seat, front passenger, how do you know that person?
He's my ex-boyfriend.
And you called him CJ. What is his full name? Do you know?
Shakir.
Okay. Do you know his last name?
Mm-mm.
No.
Is that, that's a no?
No.
All right. And so you guys are riding and then you get pulled over, correct?
Yes.
All right. And did you observe something strange happen when this was happening?
Yes, when he was turning the car to like pull over on the side street, CJ threw a baggie over.
Okay. And when you say he threw a baggie, can you explain where that came from?
I'm pretty sure it came out of his backpack. He was digging through stuff.
Okay. And then you said he threw it over. Can you describe to the court what he did, how he did that?
He just tossed it over on his left hand.
Okay. And which direction did he toss it towards?
Towards Keto.
Okay. And did you personally observe this actually happening, correct?
Yeah.
All right. And did you observe Keto have any reaction to that at all or anything like that?
No, he didn't know.
Okay.
I'm gonna object to that speculation.
Objection, speculation. Did you want to respond to that objection?
No response, Your Honor. I'll rephrase the question.
Okay.
Yeah, so did you observe anything on his facial expressions about when that bag was thrown over?
No.
No, okay.
Can I back up a little bit just for clarification? At what point, or what was going on when the baggie was being thrown over? Was this when
we were getting pulled over
when you were getting
on
pulled
the
over?
side street? He was turning and he threw the bag.
Oh, okay, so when the police were trying to execute the stop.
Yeah.
Okay, thank you.
That, can you describe what that baggie looked like to us?
It was just a small plastic baggie.
Okay, and can you tell us the color?
There was white stuff in it.
Okay.
That's all I know.
Okay, can you describe the white stuff in there? What did it look like?
I don't know, just white stuff.
Okay, and would you describe the baggie as large or small?
Small.
It's a small baggie, okay. And after that happened, did you observe that baggie anymore?
No.
Okay. Did you observe, had you been with Mr. Armstrong at all earlier that day?
No.
Okay. Well, how did you get into the vehicle? Can you explain that?
He came and got me and gave me a ride. That's it.
Okay. And how long were you guys riding before the stop happened?
Like 10 minutes.
Okay. And so with CJ, can you explain your relationship that you had with CJ to us?
He was just my friend. Well, I used to date him, and then we were friends after that. That's all.
Okay. And have you observed CJ consuming any illegal substances in the past?
I'm gonna object to relevance, Judge.
What's the relevance?
Your Honor, we're trying to lay a foundation that the substances were not Mr. Armstrong's. It would link that if she had observed Mr. CJ with those types of substances in the past, then it would go to weight of the evidence that he had those substances and not Mr. Armstrong.
Judge, it's not relevant what that particular passenger did in the past, and in fact, this witness testified, she doesn't even know what was in that bag. It hasn't been even established that she knew that those were even drugs at all. It is not relevant.
It's not relevant whether or not she saw him in the past with any substances. So objections sustained.
Thank you, Your Honor. No further questions, Your Honor. Thank you.
Okay.
Ms. Hill, when you were on scene, there were at least 4 to 5 officers. You agree?
Yeah.
And you did not make a statement to any of those 4 to 5 officers on scene. You agree?
Yeah, I did it for a reason.
Okay. So my question, you did not give a statement on scene, right?
No.
Even though you testify, you just saw your ex-boyfriend throw drugs on someone else. You did not tell anyone about that, right?
Yeah, because he was there, and I didn't want him to get mad at me.
Okay, but you didn't, correct?
Is that a no?
No, I didn't.
You just saw what you have said in your statement is very concerning that somebody would plant something on Mr. Armstrong. You were concerned then on scene, right?
Yeah.
And since this incident occurred in March of 2023, you have not come forward and made a statement to the police, correct?
Yes, I have. I talked to my attorney and everybody.
Your attorney is
Yes.
not the police. You agree with that?
Yes.
You have not made a statement to the police, correct?
No, I
And today you're making a statement essentially throwing your ex-boyfriend under the bus. You agree?
because it was his. He was the only one I had.
You agree with me that Mr. Armstrong is a fairly large man
Yeah.
and would probably take up or did take up most of the driver's seat where he was seated.
Actually, Your Honor, causes for speculation.
Did you want to address that objection?
It's not speculation, Your Honor. She was testified, she has personal knowledge, she was on scene. I'm asking her if he took up the seat, something that she observed.
That she can, I'm going to overrule the objection to the extent she can answer the question she can answer.
And that day, do you recall Mr. Armstrong taking up the majority of the driver's seat?
No,
You're saying there was room in the driver's seat?
I don't remember.
And CJ was in the front passenger seat. He had access to a window. You agree?
Yeah.
He didn't throw it out the window?
I see him throw it over on Keto. That's what I'm saying.
Are you having trouble with my questions?
No.
Okay. You agree he did not throw the
She answered
baggie
that
out?
question. She said no.
I don't recall that, Judge.
Did you say no?
You agree that he did not throw it in the back seat?
He didn't throw it in the back seat.
So it's your testimony, he just so happens to throw it on the defendant as charged in court.
Yeah.
In the past 10 years, have you been convicted of a crime involving theft, dishonesty, or false statement?
No.
Nothing further, Your Honor.
Okay, did the police ever question any of you all or in your presence on that date about the baggie that they found?
Yes.
They asked you, was it yours?
No.
They didn't ask you that?
They asked me, but it
Oh, you
wasn't.
said no?
Yes.
Okay, did they ask you, did you know who it was?
Yeah.
And what was your answer then?
I said I didn't know because I didn't want him to get mad.
Oh.
Because he was there at the same area.
Oh, they asked you in front of other people?
Yeah.
Okay. What is it that made you believe that Mr. Armstrong didn't know that this was thrown in his direction? What caused you to?
Because he was worried about getting pulled over and we were turning.
Okay, was he
wasn't
looking in
looking-
that, oh, he wasn't looking in that
No.
direction? Oh, okay. And when you saw it thrown over in that direction, did you see where it landed?
I'm pretty sure it fell in the seat or something next to the seat belt. It
Is
was
that-
like it was over the middle piece of the car or the truck. It
Okay.
fell and it slid down the seat, I think.
Okay, so the officers are trying to pull the vehicle over, and your testimony is that you see the person you identified as CJ go into his book bag or
Yeah.
backpack,
Yeah, he was digging through stuff.
digging through something. Was he digging through something before the police came or after the police were present?
After when they turned the lights on, he started digging through the
Okay.
bag.
Okay, and then through what you observed to be a plastic baggie
Yeah.
in the direction of Mr. Armstrong?
Yeah.
Okay. Redirect.
Briefly, Your Honor. Do you know if that front passenger window works? Are you familiar
I
with
don't think
mosquitoes?
it did. I don't know.
Okay. Are you telling the truth today?
Yes.
Okay. And you understand you're under oath, and that if you're not telling the truth, it
But
could.
I'm not checking, this is beyond the scope of cross-examination.
Asking her if she under oath?
Right, I just, the people who had asked her if why her story is now all of a sudden like this, and she didn't come forward with it. I just want to make sure that it's clear that she understands today she's under oath. And
You can re-advise her or ask her whether or not she's placed under oath, that's fine.
so you understand you're under oath today, correct?
Yeah,
I mean,
I don't even know what that is.
That you need to tell the truth?
I am.
Okay, and you are telling the truth today,
Yeah.
correct? All right. No further questions, Your
You
Honor.
say you don't know what being under oath is, ma'am?
Yeah, I didn't know what that meant.
Okay, when you came in and I had you raise your right hand and I had you swear to tell the truth.
Oh, okay.
Okay, you remember that?
Yeah.
Okay, so the question was, you did swear to tell the truth?
Yes.
Under the penalty of perjury?
Yes.
And that's what you're doing now, that you're telling the truth?
Yeah.
Okay. Any further questions? I'll let you cross since that was beyond the scope of.
I appreciate that, Your Honor, but I have no further questions.
Okay, may this witness be excused?
Yes, Your Honor.
Okay, thank you, Ms. Hill, you may be excused. Can you call on any other witnesses?
No further proofs for the defense, Your Honor. Thank you.
Okay, you can proceed to argument.
Thank you, Your Honor. This time I make a motion to bind over as charged. The testimony essentially is that during a valid traffic stop for an expired license plate, upon further investigation, also expired driver's license, the officers do make contact with the defendant and do decide to impound the vehicle. During the impound process, they do an inventory search. During that inventory search, they find a small baggie of methamphetamine weighing 4.5 grams, true north positive for methamphetamine. That baggie is found on the driver's seat. Ms. Hill testified and agreed that the defendant is a larger man, and so just putting that evidence and that testimony aside next to the testimony that we have from the Officer Rotuno, who found the methamphetamine. He testified that he found that towards the middle of the seat, and that he did not see that methamphetamine until after, well, he did not see it before when the defendant was still seated in the driver's seat. And so all of that circumstantial evidence certainly points to the fact that methamphetamine would have been underneath this defendant or underneath his leg while he was seated in the driver's seat. In the position that methamphetamine has been described, I would submit to the court, it is not probable or even likely that somebody could toss a baggie of meth on somebody else and it end up underneath of them, underneath their leg in the seat. I just don't see how that is physically possible. Even if the court were to believe part of Ms. Hill's testimony, which, for various reasons, I don't think she should be believed. She has not given a statement for multiple years, and here today, she comes forward to this defendant, but she testifies
for multiple years. This was
I'm
from
sorry,
March?
multiple months.
Oh,
Excuse
okay.
me, Judge, I meant multiple months. She testified that it slid, somehow hit the defendant's coat and then slid down. But again, it does not describe how the baggie ends up in the middle of the seat, which presumably would be underneath where the defendant was seated. We also have testimony that the vehicle was slow to stop. I think Officer Pellegrino said that it took at least 3 blocks for the vehicle to stop, and his training and experience that is typical for somebody who is trying to conceal illegal contraband or weapon. And so based on the totality here, Judge, certainly asking the court to bind over. If anything, Ms. Hill's testimony has only created a question of fact for a trier of fact, which would also require this court to bind over. So for those various reasons, Your Honor, I would ask for bind over.
Thank you, Your Honor. I would ask that this court not bind over and dismiss charges. I want to start with the violation of the Fourth Amendment right of my client to be free from illegal search and seizure. We heard testimony from 2 officers that they're not even clear what the inventory policy is. And an inventory policy is supposed to secure valuable items and have the inventory, and their tow record is what they describe. I've not received a tow record. The officers say one officer who actually did a search said he did not even submit a tow record. This is just a blanket reason to illegally search a vehicle. The point of
Didn't Officer Rotono say that it's a policy to inventory a vehicle that's being towed? He said that under oath.
That's correct, Your Honor, but there are no guidelines for that inventory search. They can just search it. They don't have to inventory anything. It's at the officer's discretion. If there's a
That sounds like it's a motion for the circuit court though, doesn't it?
Yes, Your Honor, but I guess I'd like to make that argument here that there's not a clear policy of the inventory search of what is or isn't to be documented, whether it's high value items or not. It is a way for the officers to illegally search the vehicle, hiding behind the veil of an inventory search. Notwithstanding that constitutional issue, the jury instruction for possession is that 1, that he possessed it, and 2, in that he knew that he possessed it. That's 12.5. In this, we heard testimony that an eyewitness saw a substance being thrown at Mr. Armstrong from the front passenger seat, and that he didn't have any reaction to that because he was looking in the opposite direction. Also, the characterization of where the bag was found, actually it was in the top right corner of the seat, and when the officer went to do the search, it slid to the middle. So it was in the top right corner of the seat, which would have been consistent with Ms. Hill's testimony of somebody throwing it at Mr. Armstrong. So it was found in the middle, but that's not where it started. The officer's testimony was when he went to look at the body cam, it was at the top right corner of the seat, not in the middle. And so that adds to Ms. Hill's testimony that it was thrown at Mr. Armstrong on his right side by the front passenger. She admitted that she did not give a statement on the scene, but she was being asked questions in front of other people in the vehicle. She was not comfortable doing that. She was here under oath, gave a statement, asked her multiple times, is she being truthful? She said she is being truthful. Therefore, I would ask in this case to be dismissed because Mr. Armstrong did not knowingly possess that substance. Nothing was found on his person. He does admit that he did not have a license and the vehicle was not properly registered, but as far as the possession of the meth, I'd ask in this case that you dismiss. Thank you, Your Honor.
Any re-argument?
Just briefly, 2 points, Your Honor. what Ms. Hill testified to, that she made a statement in front of others. The court knows from Officer Ratono's testimony that CJ was actually pulled out of the car first and arrested because he had outstanding warrants. And so he was not present when she's making her statements and she claimed to be intimidated by him. And then as far as the inventory search, certainly whether or not an officer has discretion on what to document does not make something unconstitutional. So I would still ask the court to find out.
Today was the date and the time that was set for preliminary examination, and the purpose of the preliminary examination is for the prosecution to be required to submit that they have sufficient evidence, first that a crime was committed and sufficient evidence that you committed the crime. In this case, you've been charged with count 1 of possession of a controlled substance, that being methamphetamine and or ecstasy. And so the burden is squarely upon the prosecution. That's information and evidence that's presented today that's going to be measured as to whether or not there is sufficient probable cause. The probable cause is a flexible standard. It's more than just mere suspicion that a crime was committed, but it's not nearly as much evidence as what would be needed for them to prove your guilt at trial, because at trial they need to prove it beyond any reasonable doubt. And again, it's a flexible common sense standard. The court can measure whether or not they believe that the prosecution would be able to, or the likelihood of their success at the time of trial, but the court is also the sole determiner of any credibility at the time of today's hearing. So we did hear testimony from 2 officers. They gave testimony. We started with Officer Pellegrino, who testified that on or about March 26, 2023, at the area of Oakland and Chestnut, located in city of Lansing, Ingham County, state of Michigan, that the officer did execute a traffic stop because he noticed a red Chevy Silverado driving, I believe he said westbound, with what he believed to be an expired plate, which he on testimony described that he searched in lien and confirmed through the law enforcement information network to have the plate being expired. He made contact with the occupants. He said there were 3 occupants in the vehicle, and he identified Mr. Keto Armstrong as being the driver of that vehicle, that there was no valid insurance, registration was invalid, and then the defendant admitted to his license being suspended. He testified that the vehicle was inventoried and told. Other officers appeared to provide backup. We had Officer Sean Ratono come and testify as to his assistance. He stated he provided backup to Officer Pellegrino. He indicated that the front seat passenger was a Black male, had a warrant. He was removed from the vehicle first, and then he believed the others were removed from the vehicle. Following that, the front seat passenger was at some point arrested. He indicated while under oath that a decision was made to impound the vehicle because no one had a valid license, and he inventoried or searched the vehicle as a part of that impound process. And he located a baggie on the front seat, I believe the middle of the front seat, which contained a crystallized substance. People's Exhibit 1 shows a result of the TrueNarc testing, making that substance, which he later tested to be positive for the presence of methamphetamine. I think he stated that that substance weighed 4.5 grams of methamphetamine. In order for the people to prove your guilt at the time of trial, they would have to prove, as indicated partially by your client on his argument, first, that the defendant possessed methamphetamine. Second, that the defendant knew that he possessed a controlled substance, and that third, the substance that the defendant possessed was in a mixture that weighed, in this case, 4.5 grams. The Michigan Model Criminal Jury Instructions even describes possession, and it says that possession does not necessarily mean ownership. Possession means that either the person has actual physical control of the substance or the thing, as in this example I do with the pen I'm holding now, or that the person had the right to control the substance or thing, even though it is in a different room or place. Possession may be sole, where one person alone possesses the substance or thing, or possession may be joint, where two or more people each share possession. It is not enough if the defendant merely knew about the substance or thing. The defendant possessed the substance or thing only if he or she had control of it or the right to control it, either alone or together with someone else. We had testimony today from Alyssa Hill, who was the backseat passenger of the vehicle. She testified that she was present at the time of the stop and that she stated that the person she identified as CJ, also someone she formerly dated, but attested that they were friends, at least at the time of the alleged incident. She noticed that as they were trying to make a stop, after the police had activated their lights, that she saw CJ look through his bag or backpack, and that he threw what she identified to be a baggie, clear baggie, over onto or into the direction of Mr. Armstrong, that Mr. Armstrong did not appear to notice that that item or object had been thrown in his direction. She indicated on cross that she did not tell officers about this at the time due to her fear that the party she believes is responsible, that being Mr. CJ, was present, and she didn't want him to be upset. And she was also questioned as to whether or not or why or if or not the front seat passenger threw the item out the window or in the back seat. She indicated no, she saw him see. She doesn't know why, and she indicated that she saw him throw it towards Mr. Armstrong. And so I think in measuring this testimony, there's some glaring questions here. I think that's clear. I can't answer based on the testimony today as to whether or not the items that Ms. Hill alleged to have seen thrown were items that belong to CJ, were items that belong to Mr. Armstrong, or it could be items that were jointly belonging to them. There may be a reason why Mr. CJ immediately took that out of his bag, if that in fact happened. I don't discount 1 minute what the witness has said here in court. She said it under oath. I judged her credibility to be sound as it relates to this testimony. But it still creates questions of facts because we don't know why, if that happened, he would have done that. It could have been because it belonged to Mr. Armstrong, or could be that it didn't belong to Mr. Armstrong and it was his. That's not for me to determine, though. That's for a trier of fact, and that trier of fact will take place over at the circuit court. Because as it relates to today, probable cause is sufficient that a crime was committed, and there's probable cause to believe that the defendant committed the crime. Also, this matter will be bound over to the circuit court for a bind over date. What is today's date? 28. Bind over is the 12th, correct? Yes. Okay. Bind over is going to be July 12th. That's the date that the circuit court will get the file from this court, and it sounds like your attorney will be making some motions over at the circuit court. If one of those motions is going to include a bond and issue or arraignment, then you'll have to appear then for that, but you will not need to appear on the bind over date or for a new arraignment because that's no longer necessary, okay? Mr. Armstrong.
Thank you, Your Honor.
No problem. So I will note here. Your next court date will be a pretrial in circuit court. Mr. Yang will be made aware of what that date is. You'll be in contact with him. I don't think we had a change in your address. Is that still on Picardy Street?
Yep, 5817 Bacardi.
Okay, very good. If any of that changes, you'll make sure you update the court so that you get your notices. Bond was set at 2,010%. That will continue. Any additional matters for the record?
On behalf of the people, Your Honor.
Nothing from the defense, Your Honor. Thank you.
Thank you. You're all set. Counsel, you can get your exhibit.
Oh, thank you.
Have something at 1:30. Are we running, Wilson? No.
That one I don't know, Judge. I'm back with Mr. Yang actually on Conley at 2 p.m. And I'll defer to Mr. Yang whether or not that's.
We're running Conley?
As of now, yes.
Okay, sounds
He's
good.
supposed to be in custody, so.
He is, well, I see that he's in custody. I'm pretty sure he's in custody. And then Wilson was supposed to be a writ from Clayton County. Who's handling that for your office?
Mr. Culver.
Okay, so we'll find out if that, but we're gonna be in recess for lunch.
Thank you.
Thank you.